Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 3rd February 2025 and we bring you news that matters. The first news for today is as follows. In a recent judgment, the Supreme Court of India addressed the routine application of Section 156(3) or the Criminal Procedure Code, CRPC, which empowers magistrates to direct police investigations. The court emphasized that magistrates should exercise judicial discretion and not function merely as intermediaries. They should assess whether police investigation is genuinely necessary, or if the court can proceed directly to trial, especially in straightforward cases. The court highlighted that magistrates must not mechanically order police investigations without first determining the necessity based on the case's specifics. If the allegations are straightforward, the magistrate should record evidence and proceed with the trial instead of delegating the matter to the police under Section 156(3). However, in cases requiring complex investigations that necessitate police expertise, directing a police investigation would be appropriate. This approach ensures that magistrates adopt a judicial mindset rather than acting as mere conduits. The judgment also referenced the Bharatiya Nagarik Suraksha Sanhita, BNSS, which replaces the CRPC. Under Section 175(3) of the BNSS, if a police officer refuses to register a First Information Report, FIR, the magistrate is mandated to hear the officer's reasons for refusal. This provision ensures that magistrates issue well-reasoned orders with proper judicial application of mind, thereby enhancing accountability and thoroughness in the judicial process. This ruling underscores the Supreme Court's commitment to ensuring that judicial officers exercise discretion judiciously, promoting a more efficient and fair criminal justice system. Next news. On February 1, 2025, the Supreme Court of India convened a significant conference to address pressing issues within the state judiciary. Chief Justice of India (CJI), Sanjeev Khanna, along with Supreme Court Justices B.R. Gavai and Surya Kant, led discussions with High Court Chief Justices and senior judges. The primary focus areas included strategies to fill judicial vacancies, the appointment of ad hoc judges, and the potential establishment of evening courts to mitigate case backlogs. The conference, titled the National Conference on Addressing Issues Faced by the State Judiciary, comprised 4 technical sessions. These sessions delved into topics such as narrowing the gap between case filings and disposals, identifying bottlenecks in case management, and exploring technological advancements to optimize judicial processes. Discussions also emphasized the importance of timely recruitment of judicial officers and court staff, as well as the creation of permanent IT and data cadres in all high courts. This initiative underscores the judiciary's commitment to enhancing efficiency and accessibility within the legal system, ensuring timely justice delivery across the nation. Next news. In a recent ruling, the Supreme Court of India clarified that litigants who settle disputes privately without engaging in formal alternative dispute resolution (ADR) mechanisms are not entitled to a refund of court fees. The bench, comprising Justices Pankaj Mithal and Asanuddin Amanullah, emphasized that court fee refunds are permissible only when disputes are resolved through recognized ADR processes such as arbitration, conciliation, judicial settlement, including Lok Adalat, or mediation. The case in question involved a petitioner seeking a refund of court fees after an out-of-court settlement was reached independently, without any court referral to ADR. The Supreme Court upheld the decisions of the lower courts, stating that since the settlement was not achieved through any of the specified ADR mechanisms, the petitioner was not eligible for a refund. This decision underscores the judiciary's stance that refunds of court fees are contingent upon the utilization of formal ADR channels, thereby encouraging litigants to resolve disputes through established legal frameworks. Next news. In a recent judgment, the Supreme Court of India emphasized that to convict individuals under Section 34 of the Indian Penal Code (IPC), which pertains to acts done by several persons in furtherance of common intention, it is essential to establish a prior meeting of minds among the accused. The court clarified that this shared intent must be pre-planned and not merely incidental. The bench, comprising Justices B.R. Gavai and Augustine George Massey, highlighted that for Section 34 IPC to be applicable, the prosecution must demonstrate that all accused parties had a prearranged plan and shared a common intention to commit the crime. It is necessary to prove that the criminal act was executed in furtherance of this shared intention. This ruling underscores the judiciary's insistence on concrete evidence or collaborative intent among co-accused individuals to apply Section 34 IPC, ensuring that convictions are based on clear demonstrations or shared culpability. Next news. In a recent ruling, the Supreme Court of India declared an arrest by the Enforcement Directorate (ED) as illegal and unconstitutional due to the agency's failure to present the detainee before a magistrate within the mandated 24-hour period. The individual was detained at 1111 am on the 5th of March 2022 at Delhi's IGI airport based on a look-out circular issued by the ED. However, the ED officially recorded the arrest at 1:15 am on the 6th of March 2022 and presented the individual before a magistrate at 3:00 am the same day. The court emphasized that the detainee should have been produced before the nearest magistrate within 24 hours of the initial detention, as stipulated by Article 22(2) of the Constitution. The bench, comprising Justices Abhay S. Oka and Ujjal Bhuyan, stated that the failure to do so rendered the arrest illegal and violated the individual's fundamental rights under Articles 21 and 22. Consequently, the court ruled that when such constitutional violations occur, it is the duty of the court to release the accused on bail, overriding the twin conditions for bail under Section 45(1)(2) or the Prevention of Money Laundering Act (PMLA). Next news. In a recent judgment, the Supreme Court of India emphasized the critical elements required to establish an offence under Section 304B of the Indian Penal Code (IPC), which pertains to dowry deaths. The court highlighted that trial courts often misapply this provision, leading to wrongful convictions, and called upon state judicial academies to provide appropriate training to judicial officers. The bench, comprising Justices Abhay S. Aukar and Ujjal Bhuyan, outlined the essential ingredients of Section 304B IPC as follows. A natural death. The woman's death must be caused by burns, bodily injury, or occur under circumstances other than normal. Time frame. The death must occur within 7 years of marriage. Dowry-related cruelty or harassment. The woman must have been subjected to cruelty or harassment by her husband or his relatives in connection with demands for dowry. Proximity or harassment to death. Such cruelty or harassment must have taken place sooner before her death. The court further noted that to invoke the presumption under Section 113B of the Evidence Act, it is essential for the prosecution to establish that the deceased was subjected to cruelty or harassment related to dowry demands shortly before her death. Without proving these facts, the presumption under Section 113B cannot be applied. This ruling underscores the necessity for trial courts to meticulously assess evidence against these criteria before convicting individuals under Section 304B IPC. The Supreme Court's call for enhanced training through state judicial academies aims to prevent misapplication of the law and ensure that convictions are based on a thorough understanding of the statutory requirements. Next news. In a recent decision, the Dand High Court reaffirmed that court-appointed commissioners under Order 26 Rule 10 of the Civil Procedure Code (CPC) are not to be utilized for collecting evidence on behalf of the parties involved in a suit. Justice Sanjay Kumar Dwivedi emphasized that the role of such commissioners is to elucidate matters in dispute, not to assist any party in establishing its claims. The case involved petitioners, who were defendants in a title suit, seeking the appointment of a commissioner to determine the age and size of a house structure on the disputed property. The trial court rejected this plea, leading to the present challenge before the High Court. The petitioners cited previous judgments to support their request. However, the High Court observed that the disputed property specifics were already known to both parties. The court concluded that appointing a commissioner solely to ascertain facts that should be proven through party evidence was inappropriate. This ruling underscores the judiciary's stance that the appointment of commissioners is intended to clarify disputed matters without serving as a means for parties to gather evidence, thereby maintaining the integrity of the judicial process. Next news. Delhi High Court has issued summons to Congress leader Shashi Tharoor in a defamation suit filed by BJP leader Rajiv Chandrasekhar. The suit alleges that Tharoor made defamatory statements during a television interview accusing Chandrasekhar of bribing voters in the Thiruvananthapuram constituency during the 2024 Lok Sabha elections. Justice Purushendra Kumar Kaurav has scheduled the next hearing for April 28, 2025, before the Joint Registrar. In addition to the civil defamation suit, Chandrasekhar has filed a criminal defamation complaint against Tharoor, which is currently pending before the MP/MLA's court at Rouse Avenue Courts in Delhi. The trial court is expected to decide soon whether to summon Tharoor in the criminal case. These legal actions stem from Tharoor's interview on the Malayalam news channel 24 News, where he allegedly accused Chandrasekhar of offering money to voters during the elections. Chandrasekhar contends that these statements have tarnished his reputation and contributed to his electoral defeat in 2024. Next news. In a recent judgment, the Rajasthan High Court overturned a 1991 rape conviction, highlighting the prosecution's failure to conduct a test identification parade, TIP. The court emphasized that when an accused is unknown to the victim, a tip is crucial for establishing identity. In this case, the victim identified the accused based solely on names provided by her relatives after the incident, without any direct recognition. The court deemed it unsafe to rely solely on such testimony without corroborative evidence. Consequently, the court acquitted the accused and directed the state's Director General of Police and Principal Secretary, Department of Home, to instruct investigating officers on the necessity of conducting TIPs in relevant cases. Next news. In a recent judgment, the Telangana High Court overturned the conviction of a junior engineer accused of soliciting a 50,000 rupees bribe to clear a contractor's pending bills. The court emphasized that mere recovery or tainted money is insufficient for conviction under the Prevention of Corruption Act without concrete evidence or bribe demand. Justice K. Surender noted that the accused had already signed the relevant bills and lacked authority over their final clearance, making the alleged bribe demand improbable. The court referenced Supreme Court rulings, including N. Vijaykumar v. State of Tamil Nadu and P. Satyanarayana Murthy v. District Inspector of Police State of AP, which assert that proof of illegal gratification demand is essential for such convictions. Consequently, the court extended the benefit of the doubt to the appellant and allowed the appeal. Next news. In a recent ruling, the Dand High Court upheld the disciplinary action against a former assistant commandant of the Central Industrial Security Force CISF for making caste-based remarks against a subordinate officer. The court confirmed the imposition of a 20% reduction in monthly pension and the forfeiture of the officer's entire gratuity. The bench, comprising Chief Justice M.S. Ramachandra Rao and Justice Gautam Kumar Chaudhary, emphasized that the officer's past clean conduct could not be considered a mitigating factor in the face of such serious misconduct. The court noted that the CISF is a disciplined force and leniency is not warranted when grave charges are involved. The officer had been accused of making derogatory caste-based remarks against an inspector in his office in 2008 and 2009, actions deemed unbecoming of a government servant. Despite his retirement, disciplinary proceedings continued under Rule 9 of the Central Civil Services Pension Rules, 1972, which allows for action against retired government servants if grave misconduct is established. The court upheld the disciplinary authority's decision, stating that the punishment was not shockingly disproportionate to the charges. This decision underscores the judiciary's commitment to maintaining discipline within government services and reinforces the principle that serious misconduct warrants appropriate punitive measures, irrespective of an individual's prior service record. And the final news for today is as follows. In a recent directive, the Supreme Court mandated that vehicles in the National Capital Region NCR must comply with the High Security Registration Plates HSRP Order 2018 and display color-coded stickers indicating fuel types. The court specified that certain vehicle-related services, including the issuance of pollution under control PUC certificates, transfer of ownership, addition of hypothecation, change of address, issuance or duplicate registration certificates, cancellation of hypothecation and fitness-related activities should not be processed unless the vehicles adhere to these requirements. Furthermore, the court modified its earlier order to stipulate that vehicles sold on or after April 1, 2019, must comply with the HSRP provisions. For non-compliant vehicles sold after this date, the concerned authorities are directed to initiate penal action under Section 192(1) or the Motor Vehicles Act, 1988. This directive aims to enhance vehicle security and environmental compliance within the NCR. Well, that's all for today. Keep listening to Legal News by DLC.